So I'll just start off with our set questions. And again, my goal is to try and reserve time for lots of audience questions if we have them. And maybe I'll get everybody to address this question. We can just go in order of who's next to me. But the first question we have is, so we've done this study, but why should we care about millennials, technology, and justice? And it asks each of you from your own experience and research, how would you describe what you see as a millennial influence on the justice system and the delivery of legal services? Or maybe do you even agree that there's a unique millennial influence? Because we're millennial a lot. Is it something to pay attention to, or is it just kind of the buzzword of today? So maybe, Mike, I'll get you to speak to that first.
Sure, thank you very much. Thanks for inviting me today. So from my perspective as a chair of a number of tribunals in terms of what I see, and also somebody who cares deeply about access to justice, I think you have to approach those questions with three other questions. So what do we mean by millennials and beyond the 18 to 35 group? Like, who is that and who's defining that? And in terms of influence, how are they influencing technology and justice? So on the first one, of course, there is a really wide range. I think, millennials may be, are people in this room who want to work in the legal system. But, Michael Brown from Ferguson, the late Michael Brown, he was a millennial, right? So his interaction with the justice system was very different than most of the people in this room. Tina Fontaine was a millennial, the young Aboriginal woman who was found murdered in Winnipeg. I mean, sure, her interaction with the justice system is quite different. And so I think, I guess my point is that there are other characteristics of individuals who fall within the 18 to 35 age group that may be more fundamental than simply the age and whether they use smartphones. At least when it comes to justice and access to justice, what it means to interact with justice and the importance of justice. And secondly, when we talk about who's defining people, I think that's important in our technological world because, of course, we can define our own identities and we can have multiple identities and different platforms. But, with the collection of data, and the Web 2.0, we know we are defined as well into demographics, into people who like this or that, or shop here or there, or who may be pregnant or have the flu. We're identified increasingly as individuals, and that gets to the third point, is where's the influence? And I think that when it comes to technology, at least at this point, it seems that most of our influence, whether we're millennials or boomers or whatever, are all about us being markets. And as a person with a disability, I'm often referred to as an emerging market. So that's my identity, at least in some people's view. So I think we need to ask, who are we talking about, really, when we, as a starting point?
Yeah, I think those are great comments. I would echo them as well. I tend to stay away from labels because I worry about stereotyping and because I think trends can be created much more than they're actually a reflection of a reality. In other words, trends create their own reality by telling people who they are, what it is, and what they want. And by increasingly in an artificially intelligent environment, shaping the information that arrives to people according to algorithmic predictions about who they are and what they should be interested in, therefore influencing their own sense of self and identity. So I think I worry about sort of broad strokes, labels around, like millennial, as somehow suggesting something that's evocative of whether or not access to justice could be better gained through technology. But to the extent that we're trying to describe a demographic, or like a period of people born in a period of time, it might be useful to talk about that, and I think that's probably more because of the environment than the individuals themselves, because we know for the past several decades the federal government has spent billions of dollars getting kids online and keeping them online, and so it wouldn't be surprising to find out that people in this age bracket are more connected than prior generations. I think actually what's interesting about some of the findings that are out there, if you take a look at Young Canadians in a Wired World findings, for example, the longest running, largest longitudinal study of young people's experiences online in North America, you see interesting trends changing over time, and a real question arising whether kids continue to be interested in being as connected as they have been in the past. In relation to legal services, even the findings here from advocates show that 2/3 of young people that they talked to wanted to get legal services face-to-face. So that strong preference for face-to-face interaction actually, I think, connects so-called millennials with prior generations, because there's very strong evidence in the access to justice world that vulnerable people are particularly interested in having access to legal services in a face-to-face environment. And so I think it's an interesting actual connection between this generation and past generations. I think overall we have to be cognizant of the fact, first of all, that in fact there are legal organizations that are doing amazing work putting legal information online. If you look at the work at Clio, if you look at the laws, if you just Google Legal Information Ontario, there are some actually really important, there's really important information already out there. There may be a challenge in terms of organizing it in a way that it makes it more accessible in one place. So I think overall, I think we've got to really resist the temptation to necessarily connect technology and access to justice, which is not to say we should reject the connection, but that we need to interrogate it just like anything else. We thought changing the rules of civil procedure was going to maximize access to justice. That really hasn't actually turned out to be the case. So I think we've got to be careful about this idea of adding technology plus justice equals, nirvana. I think we have to be really careful about that, and I think we have to be careful about assuming that everyone, or a majority of people in an age group, necessarily see that connection, particularly because there are demographics, there are groups within that community that have different kinds of vulnerabilities, as Michael described, and it would be really tragic to find people who most need access to justice information and legal services are the least able to connect to them because of the mechanisms we choose for delivery of those services. So that's all I'd say about that.
Okay, thank you. A couple of things from my perspective. First of all, the demographic itself. Okay? Millennials, from my perspective, are just the beginning of a demographic that's going to continue into Gen Z, etc. The distinction for millennials, they're really the first generation that have been born, being a boomer, with a mouse in their hands, or with the ability to use the internet for an unending search for knowledge or information or capabilities. And I see that my children manifest that to me, who are 11 and 12 years old, every day, and demonstrate that in a way that I've learned to understand. If it doesn't make sense to me, it doesn't really matter. I have to look at it from the perspective of somebody who's grown up in an environment where this was a reality from day one. And so, you've got 80 million millennials in North America. They are now displacing baby boomers in that area between 25 and 50 that all the important stuff happens. Okay? Whether you buy a house, whether you become a judge, whether you get elected to parliament, that's the demographic, right? That that is emerging, and the demographic behind them isn't going to revert back to baby boomer thinking. Okay? So it's going to be a continuum. Okay? In terms of access to justice, there's a couple of important things that we all need to understand. You heard that I'm a real estate lawyer, used to be a real estate lawyer. Okay? Oftentimes, access to justice is misunderstood as being access to someone who can help you in a criminal law situation, or perhaps access to someone who can help you in a civil litigation matter, or somehow where the forces of the state are brought to bear against you, or the forces of somebody else are brought to bear against you in terms of a litigious matter. Okay? From my perspective, access to justice is a much wider issue than that. Okay? People should be entitled to understand what they have to do to incorporate a company, do a will, or buy a home. That is much the same concept of access to justice as getting someone to bail you out of jail when you've been improperly arrested for a crime. Okay? And the interesting nexus between all of that, from someone who practiced primarily in Toronto, but I had the privilege of speaking to all the law associations in all the remote places in Ontario, was that the person who's doing your house deal is the person who's bailing you out. So if you start to erode away the house deal because of technological do-it-yourself stuff, the person who's going to be bailing you out is not going to be there. Okay? So it's a bigger access to justice picture, and it's sort of circular and tautological in certain cases. So that's very important. The other thing that, if you look at the marketplace and what's happened with what you call disruptors or disintermediators and things like that, I'll give you two examples, Uber and, for instance, cloud sourcing. Okay? They really run roughshod of regulatory schemes. Okay? Uber obliterated the City of Toronto taxing license scheme in about 12 months. If you go to Kijiji now, what used to cost $400,000 for a plate for a car costs $75,000. Okay? If you look at crowdsourcing, at least the last time I looked at it, right, it violates pretty well every piece of security regulation that exists in Canada. There's no offering memorandums. There's no sort of prospectuses or anything around that. Yet it's very successful, and it's overwhelmed a regulatory scheme. So, from my perspective especially, I am very concerned to the extent to which these things will simply overwhelm concepts like the unauthorized practice of law. Okay? At what point do we start to cross that line and these technological services sort of move into displacing the entire legal profession? Which, being a lawyer, but more than that, and given my experience in the US in certain areas as well, I think that's a very problematic thing, and a thing that we have to be very careful of, and something that we have to look to as we become involved in this technology as a means of providing access to justice. I see it as a valuable tool in facilitating access to justice and the provision of legal services.
So, for me, I've been drinking the access to justice plus technology equals Nirvana Kool-Aid for a few years now, until I had this kind of intellectually perplexing epiphany where I realized kind of the danger of my influence in improving the access to justice space. I just want to speak about that. There's a bit of a paradox. I created the Small Claims Wizard after I worked as a court reporter, and I saw a number of barriers for people to access legal services, to access justice. So I thought, what can I possibly offer? What can I do to potentially solve this problem I was seeing? So what's the way to do it? Of course, technology, right? So I, started drinking the technology Kool-Aid, thinking that I was going to, revolutionize and rather ambitiously, change the, the legal, access to legal services and so forth. But as I started building the product, and as I started meeting more people who would be using that product, I started witnessing a paradox. And a paradox that made me very, very uncomfortable. And, paradox is the engine of insight, so I guess perhaps it was a good thing, where I realized that I was actually doing my millennial influence, is that I was taking a socio-political problem and I was turning it into a technological problem. So the issue wasn't that there's an access to justice problem because, you know, the regulation of legal services is as such where, you know, costs are too high, or, you know, how people pay for legal services, are they bundle packs, do you pay by billables? All those questions, all those structural, systemic issues were being airbrushed by me basically introducing this technology and thinking that actually technology can all of a sudden kind of make these socio-political issues wither away. And that wasn't the case. So that was the paradox. So I introduced the technology to bring order to this disorder that is an access to justice crisis. And in the process, I was actually creating more disorder. Because instead of solving the actual problem, the problem was now a technological problem that had to be, you know, more AI, more, you know, certain features where people can access, you know, something in a particular way. So the focus, again, was being reframed. It was a technical framing of a socio-political problem. That has implications because it attenuates the need of politicians, law society, to really address the stem and the root of the problem. So I noticed the millennial influence having this bit of a paradox. I think that's all I want to say.
Sure, yeah, that's great.
So I'm just going to quickly defend the idea of labeling a group of people based on what year they were born in. You can see trends in terms of generational differences, attitudes and behaviors in between those generations. And here's an example from StatsCan. It's 2013 information, so it's a little dated. Percent of total population that purchases goods or services on the internet at least once a month, so it's probably exploded since then. Millennials 51%, Gen X 46%, Boomers 29%, and pre-Boomers 10%. And I think this is really important. I'm definitely not a legal expert, and I'm not going to speak to that. I'm not going to speak to access to justice, but it can be very useful to label groups. It is a shortcut. It is problematic, but it can be very useful.
Just to add a couple more interesting statistics to the online shopping. In the United States, for instance, for whatever reason, there's a direct correlation between vacancy rates and percentage of business done online. So if 10% of the retail business is online, somehow or other that translates into 10% vacancy rate in retail shopping centers in the United States. And we all know what's going on with the retail situation, and this isn't even in Canada. Sears is an example, where the online shopping component is virtually overwhelming the traditional bricks and mortar distribution systems.
I think Selena actually gave us a really good segue into our second question, so maybe I'll move with that. Does anybody want to say anything on the first question?
I just want to go back to the idea that if you look at the problem of access to justice as a moral and ethical problem, then you want to be sure that the approaches that you're suggesting are a reflection of this so-called demographic that you're saying you seek to serve, or whether it's a reflection of environmental patterns that create online consumers. And then, so like who's running the show here, right? And I think those are important questions to ask, right? So who's designing this agenda? You can't dispute what the statistics say about what people are doing, but when you ask the question, why is that? Then you get down to some really interesting information about the extent to which people engage in this out of a pure sense of choice, or whether there are very few other options that have been presented to a particular group of people, I think. It's a conscious policy choice, and corporate planning and agendas mesh hand in glove with it.
It makes me think of, so I'm doing some work on legal apps and privacy and the terms of service issue, right? So all the studies on terms of service say people will agree to give away their firstborn child to click through to get the latest update on their phone. What does that mean? Necessarily that they don't care about privacy, or if they just feel constrained, or they don't see the consequences yet, things like that. So Jane, you talked a little bit in that answer about things that were underneath some of those answers. Does some of your other research speak to that? You want to highlight?
About things that are underneath.
Underneath people's responses about how they're interacting with the online world.
Yeah, so I mean, when we talk to young people, this sort of seamless integration of what old folks like me used to call online offline, it's not a distinction. It's a seamlessly integrated existence, and some of it is a lot of what the younger people we're talking to tend to be talking to people under the age of 22. A lot of what they're telling us is, number one, from a social perspective, I can't not be online, or I will have no sort of social connection. Number two, schools now mandate me to do my work online. And there's a whole sort of educational software industry that's built up around that. And then three, we know that when they're in online spaces socializing, they're also being advertised to, they're also being profiled as consumers. So their social space is now a space about treating them as consumers. And they're increasingly over the years. I'm not the lead researcher on Young Canadians is Valerie Steeves, but if you look over time at attitudes, at young people's attitudes toward being online, the younger people under 22, their attitudes are shifting, and they are becoming more critical and concerned about how they're being manipulated.
Michael, do you want to ask something?
I would say is that I think some of the sort of influx of technology in justice has its roots in a pre-tech time when I think that in the legal community we had moved to more dispute resolution rather than sort of justice. Justice meaning a just outcome pronounced by a judge, and at least in the civil context, through labor law and family law, there's a lot of dispute resolution as opposed to justice, mediation. Now this is a good thing, but that kind of notion where dispute resolution is the right outcome, an acceptable outcome, or even a just outcome is defined by two equal parties reaching an agreement. And that kind of notion of justice, which is the bargain, fits perfectly into a tech world where you're looking at transactional, making a deal, marketplace kind of model.
So I think some of the themes of the second question came up in some of those answers. We'll see if people want to expand a bit. Particularly Selena, it's something you touched on when you talked about a paradox. The sense where we do see a lot of enthusiasm around technology as a way to mitigate barriers, financial, psychological, even physical barriers. But then, to go up in your answers, some other answers about whether or not, if we use technology to disrupt things and create new means of access, is that threatening core values of our justice system? And is that a real tension? How do we resolve that? It seems like the answer can't be no technology. And indeed, you're working on a really interesting service for individuals. So when you saw that paradox in your own journey, how did you see resolving it, or what are some of the questions you're asking yourself?
Yeah. The issue is that when you have computer programmers, engineers, entrepreneurs, technologists creating a platform to, I guess, with the mission to improve access to justice, their vision of what access to justice looks like is being imposed on the users. So the users have no direct say in how access to justice is being designed. So that's actually a really powerful position to have as a programmer, because my vision, my interpretation of what access to justice looks like is being constructed and created and imposed on by users and the public. So one of the ways kind of out of that is design thinking. I don't know if anyone has heard of it, but it's basically a human-centered approach to innovation. And it integrates the needs of the people, the possibilities of technology, and the requirements for business success. And and design thinking itself is a very deep human process that taps into certain abilities that we all have that are overlooked by more conventional problem-solving practices. So, for example, the ability to empathize with potential users can inform how the software is designed, how like a legal technology is being designed. For example, ensuring that PDFs that need to be filled out are compatible with certain, various dictation tools for users who are visually or learning impaired. That's one way to do that, right? Instead of like making assumptions of what like a typical user is, you actually incorporate them in the design of that software itself. So it obviously the focus is a lot on empathy and understanding users on a deeper level, and of course it's to empower people and improve and restore their confidence in to navigate the legal system. And I was going to say that, I don't know if there's any legal practitioners here, but it may be of interest to legal practitioners as well, because if you have ideas on how to do things better, whether it's to manage information, deliver services to your client, or to a potential startup that you're giving legal advice to, people who want to innovate and rejuvenate their legal practice and provide creative ways of like looking at legal issues, for example, that can improve the experiences of the attorney and the client, and that can also be kind of like imposed on the software as well to incorporate design thinking. That's one way out.
Okay. And I know Michael, this is lean offers kind of a sense in the private sector, but in the public sector, we're thinking, or our policymakers are thinking about incorporating technology and this tension between creating barriers and alleviating some. How do you go thinking about that, or what do you think are the helpful ways to think about that?
Well, I think there's a real difficulty because, again, when both Jane and I talked about the fact that there's very different people who fall within the millennial or across society in terms of their needs, how they access justice, whether they want to access justice, or whether they get pulled into the justice system and all of these things. And I think, I don't know, do they still teach Latin in law school? No, there's a Latin phrase called qui bono. It means who benefits. And I don't know, maybe millennials don't think about power anymore, but power is important. And who is driving the changes and who is behind changes. And so whether it's a market force or you asked about the public,
right,
it's the politicians who are saying government is bad, we've got to get out of government, or we have to get smaller government, or they're even, they're being pressured to do that. And technology in the sense of self-help becomes the answer, right? And which is not, Maurizio isn't necessarily working on that, but that seems to be the push. And so I think the challenge is to design things that actually are beneficial. Design thinking is great, but design isn't apolitical. There's a great story of an urban designer, architect in New York, in the mid-19th century who built road parkways to Long Island, and all of the overpasses have a really low clearance, right? And people thought, oh, like you made a mistake about this, but it wasn't a mistake, right? Because the poor people would have to take buses, and the buses couldn't get to Long Island, right? And so, how you design the architecture is going to fundamentally affect, the access to justice. And so the question is, when public funds are being spent, are you just chasing the middle class vote, or are you looking at people who are the most vulnerable, who need justice in justice in the sense of speaking truth to power or changing, really looking at the quality.
Right, so if I heard you right in your answer to the first question, you talked about particularly in maybe some more remote areas the need to have lawyers still involved and having a one-stop shop, having some helpful aspects to it. Is that your perspective in some of these initiatives? We still need the people to be people plus technology instead of just technology, or?
Well, I was just trying to point out that my interpretation of access to justice perhaps goes well beyond what many traditional people think they mean by access to justice, because in my opinion, I believe if you're buying a home, you should have access to legal advice so that you're properly informed when you buy a home, or you do a will, or you incorporate a company, or you get tax advice. And from the delivery of legal services perspective, although, I have a luxury of living in Toronto, I guess, from a practice perspective, but that doesn't exist outside of urban centers. You're practicing in all areas, and you need to be fluent in all areas to be able to deliver any type of access to justice in these locations. But getting back to the technological issues, see, there's two core things that I frankly believe are undeniable. Okay? If you can inform people better, isn't there probability of having access to justice increased? If you have a better informed consumer, regardless of what area of access, right, that you're worried about. And I see the internet and web systems as a fundamental tool of that. Okay. The second thing is when we're talking about trashing traditional core values, it's very important to distinguish between traditional ideas of how legal services or access to justice has to be traditionally delivered, right? Which is, in my opinion, steeped in legacy systems and approaches that may no longer be relevant, right? And unless the legal profession moves forward, we may be left behind. And I find that, perfect examples when I'm looking at designing our systems, because I'm in the private sector, designing systems for lawyers to use on the web and for clients to use on the web to interact with lawyers. And you'll be surprised to see the difference between asking a lawyer how they like the system to work, which is basically should work exactly as I'm doing right now, don't make any changes because I'm used to it, right? Which is consistent with our entire upbringing as lawyers, because our entire world is based on stare decisis and precedent, right? So it's not like the legal profession inherently moves forward quickly. If you look at it in relation to other areas, even mortgage banking or banking, as the report talked about. And when you interview clients and what they would like to see interacting with lawyers, and just to wrap up, perfect example was in our systems, we put instant messaging in between the legal firm and the client, right? I thought that was a wonderful idea for a number of reasons, including helping the lawyer manage all the correspondence, and it's electronically immediately associated with the file, as opposed to what you do now with an email. You print them off, put paper copies in the file, and have email management systems. 80% of my lawyers for user groups were saying, take that out. Take that out, because now I got to worry about emails, faxes, phone calls, letters. That's just another avenue of things I have to manage. So that's one of the problems we're facing in terms of how, when we talk about core values, we can't confuse core values with traditional means or methods. And I find the two get very wrapped up.
Great, thanks. Right, so maybe you didn't have a chance actually to explain what your product is. Can you do that really quickly for us?
Well, we run a bunch of web service tools for lawyers. Okay, so if you're doing real estate deals, if you're managing corporations, if you're doing wills, if you're getting electronic, if you're handling mortgages for a bank, right? Which was a huge initiative, because 20 years ago everything went by fax, which is crazy from privacy, security.
20 years ago, probably like.
Well, 3 years ago, actually. Still goes on now. We've electronically linked the legal profession with lenders. So everything happens electronically, for instance. All those types of initiatives we're moving forward with, getting electronic signatures in areas, trying to put, which is, if you look at the Law Society rules of electronic signatures, they were still struggling with a digital signature, a digital certificate, and an electronic signature. An electronic signature is nothing more, right, than imagine a computer with a pen sticking out. That's all it is. It's another means of electronically affixing your signature. It's not a means of certifying or validating who you are, like a digital certificate is. And when they amended the rules, for instance, in Ontario, on whether agreements for purchase and sale in the Electronic Commerce Act could be signed electronically, the Law Society's first blush on it was it started to put rules around that were about digital certificates, which completely wrote off the value to electronic signatures, since the people who would be electronically signing are consumers who aren't going to go through the certification process involved in getting a digital certification and the cost and, for a one-time offer. So these are the types of hurdles when we're talking about traditional delivery mechanisms, right? It was very difficult to get the Law Society to start to understand the difference.
Hopefully they'll watch it. We'll video recordings. Hopefully we can just send this to them.
Well, no, I was chairman of a number of entities for them, so we've had these discussions.
Okay.
They've evolved. It's just difficult to move forward.
Right. Maybe I'll move us a question for in view of the time. And one of the really helpful things of having this survey is often we can have these conversations about access to justice a little bit in an empirical vacuum. So make assumptions or make statements about what different groups of people want. And so actually I was wondering if you could talk maybe a little bit about what you see as the highlights from what you found and maybe even a little bit of methodologically how you came up with your questions and conducted your survey.
Wow, you blindsided me.
Well, I guess the question was, what do millennials want from the justice sector, and was, having been involved in this study, what do you think the study tells us about
I mean,
that?
that's not really how we approached it.
Okay.
And I wouldn't frame it in that way of what millennials want from the justice system.
Okay.
We approached it more as if businesses, if legal services were to go online, what would be the challenges, what would be the opportunities? And I mean, some highlights were definitely that it's not as easy as we thought it would be. So other sectors like banking and fitness, there's fewer hesitation, there's less hesitation from the cohort than something like legal services, because there's and again, I'm not a legal expert, but just in terms of perceptions as millennials, there's a mysticism around it. There's a credibility, an insistence on credibility that they want from somebody who's providing legal services that the digital sphere is lacking a little bit. Maybe there's a misunderstanding, maybe there's a lack of credibility. That's something else that we have to explore.
Okay. I read the results. I know it's one thing that people were particularly hesitant about is if there's a need to upload identification.
Right.
Can you tell us about those findings?
Sure. So that was basically the biggest roadblock that we found. Almost a third of respondents were millennials in Ontario were too uncomfortable, or said they were too uncomfortable to upload legal identification if this was part of whatever service they were using. And the big reveal behind that was that it wasn't privacy concerns, it was identity theft. That was the big issue for them. So of that third, over half were concerned with identity theft. So that's something that was surprising to us and might be very useful for digital legal service providers is how do you frame, or what do you do about this sort of challenge with millennials? How do you get them to understand that your system is secure, that it's worth this risk that they perceive of uploading the documents to get the services that they want?
Okay, thanks. Celine, I know you have a product, and there's millennials that use it and non-millennials. I think you've done a focus group with users, and I remember we talked before with this issue of trust and credibility, and maybe you can speak to your experience qualitatively of how people have reacted to your product and on that.
Yes, so based on my many hours of conducting focus studies and meeting people who were interested in using a potential software system to start or commence a claim at the small claims court. I mean, millennials or the younger people, or I guess this undefined millennial, everyone kind of wants the same thing, right? You want something that's not that expensive, convenient, timely, all very basic kind of wants from the justice sector. And just based on the study that's been cited here, a lot, the people that were surveyed, I think about 69% said that technology held great promise for them, and helping them kind of address their legal issues, particularly in law and housing law and employment. And yeah, so the issue that came up was, like, how legit is this, right? And one of the potential solutions was maybe having a best practices, a guideline or something that the users and the public, millennials of all ages, would be able to feel comfortable to use technology as a way to kind of experience a better experience trying to access the legal system for whatever means they have. I think, technology giveth and technology taketh, like I said earlier, and there's a bit of a issue with law society not being particularly too open. You kind of want to stand corners around innovation. You don't really want to change things. So I think that part of the question that I asked, do you think that how the justice sector will respond? I don't know how. I think they are open to technology flourishing and people coming up with various ideas to solve legal problems that have moral and socio elements to them. But John Keynes, he argued about the gradual encroachment of ideas, and gradual encroachment of ideas being far more influential to political life and than the greatly exaggerated powers of vested interest. In this case, I would think the vested interest would be like the status quo of the legal system. So in order for, I guess, the law society and future lawyers and lawyers who are currently part of professionals today, in order for them to kind of be more open to embrace and use technology, not to replace them, but to rejuvenate their practice. Like even the software that I'm building, it's not to remove the lawyer out of the picture, it's just to facilitate and improve the user experience that can be used in conjunction with the lawyer. So, in order for it to get to that point, just like Keynes, these ideas of innovation and kind of taking a forward-thinking approach to law is honed in university, is honed through these panel talks, is honed through these studies, and slowly but surely, I think I'm maybe optimistic to some extent that there will be some kind of acceptance of technology being combined with kind of a human element to address some of these issues. This is what happened to Keynes, and I hope it's going to happen to legal technologists as well.
Yeah, thanks. Move the questions to I wonder if Jane, are you keen to?
Yeah, I do. I am keen.
Okay.
And the reason is because I'm usually seen as technophobic and anti-technology, and probably in a way I am, but only really because of the way it's portrayed. I think actually technology offers us some really important opportunities that I think we might be missing, because we look at technology as a way of tinkering around the edges. But we really should look at technology. Technology is this presentation, if it's a disruptive force, looking at our system and saying, why is this so broken? What's going on here? What's wrong with the system? Not how can we build an app to, it sort of goes back to Selena's earlier point, right? And to the sort of issue around what might slow millennials down. I think that what I thought was really amazing about the Abacus results was that in every category, except for two, where identity theft was named as the primary concern, the primary concern about sharing information online was privacy. So we have had decades of self-interested corporate leaders telling us privacy is dead, forget about it. And people still, in this survey, and it's supported by certainly, if you look at Young Canadian Studies from 2012, 2014, it's repeated over and over again. So notwithstanding everything in the environment that's telling young people, forget it, forget about privacy. You don't care about your privacy. You post things on social media. They continue to say, no, no, we care about our privacy. And in particular, we care about our privacy in relation to corporations having access to it. And we care about what is done with our information. So you may look at, when we talk to young people, you may look at my practices and say, well, if I disclose all that online, clearly I don't care about privacy. To which they respond, no, no. The way I deal with privacy is there's rules about who can see it and how they can use it. Privacy isn't just about disclosure, it's about collection and use as well. So I thought that was a sort of phenomenal outcome of the study. And it's something, again, and we see this time and again in legal system applications, it's going to be critical. You know, if you look at the Google algorithm that now can disclose names of witnesses and victims whose names were not to be disclosed under publication bans through Google searches, we have serious privacy issues for the legal sector. So I just thought that was a phenomenally important outcome of these results, and a really critical message for the Law Society and other legal players. So I'm interested. Yeah. Michael, do you want to have a closing word?
Yeah, just quickly. I think, I mean, I agree with Jane, and it's particularly challenging for public justice systems. And, you know, I get back to what I said before, that we have a whole burgeoning, developing industry, if you want, like private dispute resolutions, which may have a different set of norms, although maybe not, given the results of the survey. But you know, I can tell you, as somebody who works within the public justice system, it is like the worst thing that can happen is a privacy breach. I mean, ministers resign their posts. They have to resign their seats. People get fired. I mean, you cannot, quite properly, have privacy breaches when you're dealing with public records. And yet, in the private sector, there seems to be, at least to date, less concern. I mean, it's in the news, but it's not as deadly. And I think what is interesting is what Jane says. I think the private providers, tech providers, have to take note of what millennials feel.
Maybe I'll open up the questions in about 15 minutes. There's a lot of content there, and we have a lot of expertise there. So I see Karen in the back.
I haven't read the Abacus study yet. I look forward to doing so. I wanted to ask a question related to what I think maybe was a bit unsaid in today's presentations, which is the millennial not as a recipient of legal services, but the millennial as someone who participates in creating and delivering legal services. Celine, I think you spoke to it a little bit. But, you know, I think that there's another perspective on this conversation, which is how do new lawyers participate in this changing marketplace with what they bring as sort of a really unique perspectives on relationships in a digital world. And so, you know, I think we heard some really insightful cautions about the marketplace and what the marketplace does to shape our lives. But I think, you know, if you look at something like legal literacy and using technology to increase legal literacy in the world, and you think about something that exists far outside of market forces, like using a game in a nonprofit context to have young people understand their rights. You know, I think there's some really interesting spaces for new legal professionals to participate. And so my question to the panel is, how do you encourage new lawyers to experiment and to think about new forms of service delivery without entering into those murky waters of what Mauricio characterized as sort of the confusion between core values and traditional ways of delivering legal services?
That is one of my questions. I thought Maurizio did.
I had a note to say exactly what you said in terms of we're talking about the millennials and whoever comes after them, Gen Zers, as recipients of what I call legal services. They're also, because they're starting to be the predominant group in the marketplace, the providers of legal services, and they're also going to be the dispensers of justice in terms of who our judges are going to be and how the Supreme Court of Canada is going to rule on things. And you're going to notice a significant difference, in my opinion, for instance, on how the Supreme Court of Canada looks at a monopoly over information now, which is a case that's up there with the MLS system, and whether they're successful, and how a Supreme Court of Canada, even in 10 years, looks at a monopoly over information. There'll be fundamental changes, right, in terms of how they think about those things. And I think that, so I think your point is very important because it's going to change significantly in terms of how the millennials want to provide legal services.
Yeah, or I guess even my question to Jane and Michael would be, where do you play? Like where do you participate if you're coming into the industry and you have some questions and you have some ideas, but you also want to do so in an ethical manner?
I think two things. I think one is, I think there's a lot of things, and with respect to Maurizio, and I think the work he's doing is great, but I kind of disagree that we have to think expansively of what access to justice is. I actually think we have to be more discriminating, and there's a lot of stuff that is legal work that no longer will be legal work. Legal work, there's a lot of stuff that's legal work because lawyers do it, and lawyers traditionally did it, right? I mean, I think of an example of I heard something on the radio about having a non-binary gender identification on driver's licenses, and in Newfoundland they said, well, just bring a doctor's note and you're allowed to put an X. And the individual out there says it's not a medical issue, right? It used to be a medical issue, but it's not a medical issue anymore. And I think there's a whole bunch of stuff that is seen to be legal work only because lawyers have traditionally done it. So I think that I think millennials may well, having the benefit of technology to do routine stuff, may well be able to do that. Won't be legal work. On the flip side, I would say looking at specific needs of specific individuals who are either equality seeking or equality needing pieces. So there's an app that was developed where individuals who are stopped by police have an app on their cell phone that records the interaction and immediately uploads it. So if they get shot or beaten up, it's preserved.
By you, Oprah.
Yeah, so I mean, there's an example of where somebody saw a particular legal issue, not a traditional legal issue, not a system-wide legal issue, but a particular need for a particular population that has problems accessing justice. I mean, they get lots of access to the justice system, which is bad, but problems accessing justice. And I think it's things like that that millennials can see and should focus on.
Jane, you want to add to that?
Yeah, I mean, the only other thing I would say, because I think about it in the context of my own day-to-day work. So one of our partners on the Equality Project is Media Smarts, which is Canada's leading digital literacy educator. And so they do a variety of work bringing information to children, usually through school curriculum. And some of the work that we're starting to do and could easily be done by any millennial interested in legal practice, in trying to figure out what would a curriculum look like that could be online that would deliver information to young people about their privacy rights, for example, or how to make a human rights complaint, or So there's all kinds of room in the educational space as well for people with legal training to bring their skills to bear and to use technology as a platform for delivery of information that I think is actually really interesting and exciting.
Thanks. Just have some other questions. Back to everybody.
So one of the issues that I often see is that people have really easy access to legal information, but that access doesn't transfer to justice. So for instance, I get a lot of potential clients who call me who have had enough information to begin a legal proceeding, whether it's in a tribunal, in small claims, or superior court, but that they don't actually, and they have the assumption that the information they have online is all they need to get themselves through it. But then they call me when things have gone really wrong and they get in a worse situation than they started out. So how do you think access to justice technology can interfere at an earlier stage before, as opposed to just kind of giving information to walk you, outlining how to file a claim, how to go through the process? How do you think it can really dig in and help people go from information to justice?
Any people that sleep in here?
I can answer afterwards. I'm thinking.
Okay, Jane first.
Well, I would just say, I mean, like the automatic thing I'm thinking of is an integrated people and technology solution, right? So that you give people access to lawyers, and then you have a government that's committed to putting some resources into that. And when you look at the work that the CBA is doing on bundled and unbundled legal services, the idea that if you gave people some legal information that connected them with someone with expertise to do a bit up front, and things got on the rails the proper way in the beginning, then maybe the lawyer is actually not even necessary later on. So that would be, to me, that would be one way that you could think about an integrated response.
Everybody else do it.
Well, a couple of things. There was a system which unfortunately is closed down, but there's a system in the Netherlands that supported family law litigants and also provided support after separation. So, for example, one of the components was just like an Outlook calendar, and so parents who shared custody, if somebody wanted to change a particular visitation or a particular day that they were going to have the child or the children, they could just go online and make that request, and it would update both calendars. And so it's kind of like dispute avoidance, because the theory was, and I think it worked, that sometimes those kinds of interactions could quickly break down into fights and emotional fighting and so forth, and this facilitated that kind of interaction. I mean, we're one of our tribunals, the Landlord and Tenant Board, and we're starting to work on an ODR platform, and I hope part of that could be a communication platform between tenants and landlords that would allow people to send messages so before the dispute actually arose. So to use technology to help those kinds of situations where communication is so vital to avoiding disputes.
Selena?
Yeah, I was going to say, I guess it just depends on, like for example, one of the features we're kind of working on right now for the small claims wizard is to help the user tell their legal story. So, if you misrepresent information or you don't fill out the forms properly, then you got to refile it, and you got to pay another $100 to refile your claim. So, and I guess one of the features is, for example, being able to very simply identify certain legal issues, like somebody owes me money, or I don't know, like my neighbor did something, or whatever. And through certain selections, certain facts that are relevant to the law are selected for you, and your legal story is told for you. So I'm thinking, technology can help up to a certain point, and I think the technology, as you are, let's say, filling out the forms, can provide some form of reminder. You should probably speak to someone before you finish off this particular part of your claim. So I agree with the human-techno entanglement as kind of a combination that should work together before, obviously, problems get so bad that when they come to you, it's like, where do we go from there? Right?
I think with that, we're going to have to end today because we vacate the room for the class coming in. But if you could join me in thanking our wonderful